the September 8th meeting of the Williamsburg City Council to order. Ms. Scott, would you call the roll, please?
Ms. Knudsen. Mr. Pons.
Here.
Mayor Holman.
Here.
Mr. Freiling.
Here.
Mr. Foster.
Here. First order of business for today is the council minutes from the meetings of August 8th and August 11th and the August 27th retreat of City Council. Are there any additions or corrections to the minutes? Hearing none, I'll take a motion to approve.
Mr. Mayor, I'll move the approval of the minutes of August 8th, 11th, and 27th.
Second.
I have a motion and a second. Would you call the roll, please, Ms. Scott?
Ms. Knudsen.
Aye.
Mr. Pons.
Aye.
Mayor Holman.
Aye.
Mr. Freiling.
Aye.
Mr. Foster.
Next order of business is matters of special privilege, and I believe we have none today. Is that correct? I believe so. That moves us to public hearings. Today we have 3 public hearings. I'm going to make a change in the agenda. We'll have the first 2 public hearings, and then we're going to move the first of the city manager reports, financing the quarter path at Williamsburg core infrastructure, to follow those first 2 public hearings, and then we'll go back to public hearings number 3 with the local adoption of regional water supply. We have people here from the developer and from Riverside that we don't want to keep here forever. So we'll do that if that's okay with council. Is that okay? Okay, the first public hearing is PC R11-08, which is an amendment of zoning regulations pertaining to rental bedrooms to roomers in owner-occupied single-family detached dwellings. This is proposed ordinance 11-14A and 11-14B. Mr. Nestor.
I'll briefly go over some highlights on this issue. What you see on the slide is a timeline of the consideration of this proposal, which began back in March of this year. Council, counting the meeting today, will have considered this for 4 meetings. Planning Commission considered this for 6 meetings, including 2 public hearings.
Would you go back to that just a second? This process of council sending something to Planning Commission for consideration, that's the normal process of public discussion for a zoning change. Is that correct?
Some council can send it back, yes. That's.
But sort of the process of council discussion, then Planning Commission debate, their recommendation, and then council consideration.
Yes.
Okay.
These are I'm going to go over the 3 alternatives very briefly and then talk about the differences in the existing and proposed parking regulations. Alternate 1 is no change to existing regulations. So with this alternate, rental of 1 bedroom to 1 roomer is allowed by right. Rental of 1 or 2 bedrooms to 2, 3, or 4 roomers with no more than 2 per room requires special exception approval by the Board of Zoning Appeals, and that's been in our zoning ordinance since 1991. Alternate 2 created separate sections for bedroom rental to visitors, which covers bed and breakfast, and bedroom rentals to roomers. This clarifies the differences between the 2. Rental of 1 bedroom to 1 roomer continues to be allowed by right. Rental of bedrooms to 2 roomers is allowed with administrative approval by the zoning administrator. Owner occupancy is redefined and does not allow corporate ownership for rental of rooms to roomers. Alternate 3 is the same as alternate number 2, but it adds rental of bedrooms to 3 or 4 roomers with special exception approval by the Board of Zoning Appeals. Now that's similar to what is in our existing regulations in effect today, except our regulations now allow a maximum of 2 bedrooms to 2 roomers each to get your maximum of 4, where the proposed alternate 3 could allow rental of 4 bedrooms to 1 roomer each. So that's one of the differences between the two. Planning Commission considered all 3 of these options in its last public hearing on August 17th. The Commission decided first by a vote of 7-0 that alternate 3 was not acceptable. Planning Commission then recommended by a vote of 4-3 that no change be made to the existing regulations. That is alternate 1. Now I'd like to conclude my comments by talking about the differences in the parking regulations between what we have now and what is proposed. The existing requirements requires all parking to be off-street. So it has to be in your yard, has to be on paved driveways, parking space. Well, it has to meet all the requirements, and there's a 30% coverage maximum in the front yard, for example. If you have more than 5 spaces, it needs to be hard surfaced. In our existing regulations, if you're renting to more than 1 roomer, which requires Board of Zoning Appeals approval as a special exception, you need 1 off-street parking space per roomer. So if you rented to the maximum of 4 roomers, you would need 4 off-street parking spaces. For both alternate 2 and alternate 3, parking can be either on the street, directly abutting the property, if you have the space and you need 18 feet of length per car, or it can be off-street. And you need 1 space. For alternate 2, you need 1 space per bedroom, plus 2 for the dwelling. So if you rented 1 bedroom to 2 roomers, you would need 1 additional space. If you rented 2 bedrooms to 2 roomers, you would need 2 additional spaces. For alternate 3, when you would be renting to 3 or 4 roomers, if you're renting separate bedrooms for each roomer, you would need 1 space per bedroom. If you're doubling up and renting 2 bedrooms to 2 roomers each for a total of 4, you would need 2 additional off-street parking spaces. So that's just a comparison with where we are now and what the proposed provisions are. And those are all the comments I have now. For now, I'd be glad to answer any questions.
Yeah, we'll come to council for questions before we do the open hearing, or open the hearing. And Reed, I have a number of questions for you that I think might help clarify some of this. So back to option 1, which is what exists right now, and this has been in the zoning ordinance for 20 years,
Yes.
right? And that's the 1 by right and a limitation of 2 rooms, but up to 4 roomers, but anything over 1 would have to be BZA approval by a special exception.
Correct.
Right? And this only applies to owner-occupied, single-family, detached dwellings.
Correct.
So, and it applies to those single-family detached dwellings wherever they are in the city?
Correct.
Okay. And if BZA were to approve 2, 3, or 4, does that go with the owner of the property or with the property itself? This may be a question for Chris.
These have generally gone with the owner, and we have given council some language to clarify that in the event that council either passes alternate 2 or alternate 3, that these special exception for alternate 3 would go with the owner, not with the property. So if there is a change in the property ownership or the owner ceases to occupy the property, then the special exception would be void.
Okay, and how does the city know whether there's been a change in ownership or what have you?
There is no other mechanism other than normal zoning enforcement.
I thought of ownership.
There's a certification of ownership at the beginning of either administrative approval, and they would have to certify their ownership if they applied for a special exception. And then if the special exception period is limited or the administrative approval is limited for a period of time, if they wanted to do that after, they would have to come again and resubmit the proposed ordinance.
Chris, this may be for you as well. How does the BZA special exception interact with the 3-4-person rule? Are these two separate entities, or how do you think about that, or how should we think about that?
The special exception process is just a special exception. It is an exception to the general zoning. The general zoning allows 3 unrelated people to reside in a property or a family to reside in a property. If a special exception is granted, then that would supersede general zoning.
Right. So there's no conflict there
No.
because of the nature. Okay. If someone makes an application to BZA for either 2, 3, or 4 roomers, what type of notice is given about that process?
Pass that one.
Yeah. All sorts of notifications that are given. You get a notification of the public notice in the meeting if you signed up on our website for e-notify. We put one of our green zoning signs up on the property to identify it. We send out
regulation of 1 off-street parking per roomer. Right? So, what if a property has a legal non-conforming use? Let's say I have a house and I want to have roomers, but I also have a garage apartment in the back that's legal garage apartment. What's the relationship between, are those two separate things? Does that limit my ability to rent a room?
They are two separate things.
Two separate. What about if I had a basement apartment rather than a garage apartment? Is that the same?
That would be the same.
Treated the same? Okay. When an application is made to the Board of Zoning Appeal, BZA, what criteria or what can they consider in their in making a determination of whether to approve this or not to approve this?
Okay.
Chris, you may.
Well, in addition to those things that are specific to the special exception that we're dealing with, so in this case it would be what the conditions are for rooms to roomers. The city code also provides that BZA can look at a number of things. So they look at the stated intent of the zoning district in which the property is located, the amount of area immediately surrounding the property in question, the amount of traffic generated, the number of people who would be employed if the special exception were granted, any hardships that would result if the BZA denied the special exception, and then whatever the specific criteria is. They are also required to find that whatever the special exception, if it's construction, it's designed or constructed or it's operated with safeguards for the health, safety, and welfare of the occupants of the adjoining property and the surrounding property, that it doesn't reasonably impair an adequate supply of light and air to the adjacent property, that it does not increase public danger from fire or otherwise reasonably restrict public safety, and it does not impair the established property values in the surrounding areas. So those are all things that the BZA is permitted to look at in every special exception that they consider.
Okay. So they have a great deal of latitude in
They do.
what to consider. Okay. Does the current ordinance provide a limit to the length of time of the special exception?
No.
It does not.
The proposed ordinance also does not, and Reed and I have worked on language for council to consider that would specifically limit, but BZA in a special exception has the ability to limit the amount of time that a special exception is valid for.
Okay. So while the current ordinance does not have a limitation, BZA in their
Yes. determination
could put a
Yes.
limit on it, and council could create a limit if we so desired in the
Yes.
ordinance?
Yes.
Okay. The city has a rental inspection program. Could the city specify an inspection for applicants for roomers?
The rental inspection statute specifically provides that we cannot perform rental inspections on owner-occupied properties. So insofar as rental inspection is concerned, no, we could not include that.
Could BZA make that a condition of their?
It is likely that would violate the Dillon rule because there is a specific provision in the state code that provides that we cannot do owner-occupied inspections in rental inspection context. There is nothing specific in the code that says whether or not inspections can be provided as part of this BZA zoning process. I think if we had to weigh that, it would not come down in favor of the BZA having the authority to do that. What's reasonable depends on what the state code allows currently. There are specific conditions. For example, if alcoholic beverages are going to be served, there are special conditions that can be attached to a special exception process for those. Again, the code is silent on what those conditions can be, but they must be reasonable as to the special exception that's being considered.
And reasonable is in relation to the zoning district and
That's right.
and all. Yeah. Okay. Reed, in the last 20 years, how many applications have been made to BZA for special exceptions?
5.
5. Could you tell us a little bit about those 5?
Yes, the first one we actually had the ordinance for almost 11 years before we had the first request. In 2002, there was a request at 333 Burns Lane to rent 2 bedrooms to a total of 2 roomers. That was denied by the Board of Zoning Appeals. In December of 2005, there was a request at 2 Cole Lane to rent 2 bedrooms to a total of 2 roomers. That was approved by the Board of Zoning Appeals. In September of 2006, there was a request at 349 Scotland Street, the corner of Henry and Scotland, to rent 2 bedrooms to 4 roomers. That was denied by the Board of Zoning Appeals. In October of 2009, there was a request to rent 1 bedroom to 2 roomers at 123 Matoka Court. That was approved with conditions by the Board of Zoning Appeals. And in February of this year, there was a request to rent 2 bedrooms to 4 roomers at 123 Matoka Court, which would have replaced the one I just mentioned. That was approved with conditions by the Board of Zoning Appeals.
So there have been 2 for 2 roomers, 1 denied and 2 approved, and 2 for 4 roomers, 1 approved and 1 denied.
Correct.
Okay, thank you. On option 2, I have a couple questions too. The alternate 2, instead of compared to the current ordinance, does not allow a 3rd or 4th roomer. Is that correct?
Correct. 2 is the maximum.
2 is the maximum, but the second is by administrative approval.
That's correct.
Okay. And there's there's no limitation to that in the proposed, but just as with the existing ordinance, council could impose a limitation on that. Is that correct?
There could, for administrative approval, if there were to be a time limitation, that would need to be written into the ordinance.
The ordinance, yeah. And council could do that if it so
That's
desired.
correct.
Okay. I think you've talked about the parking changes, and this changes to, from what it currently exists, all the parking spaces have to be on site to parking spaces could be on the street in front of the house as well as on site.
That's correct.
And it changes the numbers that you've talked about. Okay. Could you tell, and Chris, this may be for you, this seems to me to clarify the definition of owner occupancy in a way that is useful. Could you tell us a little bit about sort of how that clarifies?
In the previous or in the existing ordinance, owner occupancy is defined, and Reed, you can help me with this if you would, as the person who owns the property, residing in the property, they have to own 51% interest in the property, and there can be corporate ownership of the property, and this was for visitors and roomers, and so B&Bs fit into that definition as well, which is why that's part of the definition.
Excuse me, Mayor, I beg your pardon, but could the city attorney maybe move the mic a little closer? We're not able to hear in the back.
Yeah, thank you very much.
In the proposed ordinance, we've separated out visitors and roomers, so they're two separate categories. And so as we have defined owner, the person has to own the fee simple interest in the house. They have to own at least 51% of the fee simple interest in the house. Or a person in a family can reside in the house, and someone in the family has to own 51% interest. And we have specifically accepted corporate ownership or ownership by a business entity for purposes of roomers, with the intent being that that is inconsistent with renting rooms to roomers in owner-occupied properties.
Okay. So as I understand it, the changes that you've made here really have two parts to it. One, maybe clarifying the definition of owner occupancy and separating the definition of rental of rooms to roomers from rental of rooms to visitors.
That's correct.
Okay. Okay. Now, in option 3, which essentially is option 2 with the possibility of 3 or 4 by BZA approval, that differs from what exists now in what ways? The approval process.
Well, the approval process in applying to the Board of Zoning Appeals for special exception is the same in both instances. Of course, right now you need BZA approval for 2, but if you're talking about to have 3 or 4 roomers under what we have now and under what's proposed in alternate 3, you have to go to the Board of Zoning Appeals. They have to hold a public hearing with all the appropriate public notices.
And the change is in dealing with the second roomer, and that would be by administrative approval.
That would be by administrative approval. Yes, that's part of alternate 3 also. In this. So that is a more streamlined process than we have today.
Okay. And you've talked again about how parking differs between these two. How does the number of rooms that can be used for roomers differ between this and what exists now?
What exists now there are a maximum of 2 bedrooms that can be rented. Under the proposal, there is no maximum on the number of bedrooms that can be rented. There's a if you rent to 3 or 4, there's a maximum of 2 people in a bedroom. So under alternate 3, you could conceivably rent 4 bedrooms to one person each for a total of 4, whereas under our existing regulations, to get your total of 4, you would have to have 2 people each in 2 bedrooms.
Okay, that helps. And this option also picks up the clarification of owner occupancy and clarifies the distinction between renting rooms to renters versus renting rooms to visitors.
Yes, it does.
That's all, that's continued
Yes.
in this, okay. Again, does this option have any length of time to the approval, either the administrative approval or the BZA approval?
There is no option in the ordinance that was presented. It would be possible to add that for both administrative approval and Board of Zoning Appeals.
So just as we could with what exists now, add a limitation on the time period, we could do that for both the administrative approval and the BZA approval in the ordinance.
In the ordinance, correct.
Okay. Okay, I think that answers most of my questions. We'll go to council. Mr. Friday?
I think I may actually have 1 or 2 more, as much as it surprises me. Chris, I think this question is for you. Can you clarify that, I believe it was the July meeting, Planning Commission voted and made a recommendation, and then council asked Planning Commission to hold another public hearing. They did in August. They voted twice, the end result of that making a different recommendation. Did that second recommendation then override the first recommendation?
Yes.
Okay, just want to make sure that's the case. And this could be for either of you. It seems from what Reed has presented and from the mayor's questioning that when we're talking specifically about the approval process, the primary difference between option 1 and option 3 is the second rumor. And it's in option 3, it's changing it from a BZA special exception approval to administrative approval.
That's correct.
My understanding is that the thought there was that might streamline a process without creating greater hardship or interfering with the single-family nature of the neighborhood. Could one of you describe what it is about the BZA special exception approval process that makes it more cumbersome or less desirable for an applicant?
With administrative approval, let me talk about that first. You would come in and make your application, provide the information that is specified in the ordinance. The zoning administrator would check it out. If it meets all the requirements, you would receive your administrative approval. So you meet the requirements, you receive the approval. You meet the requirements and you receive your approval for the administrative part of it. Now, for Board of Zoning Appeals approval, that is discretionary on the part of the Board of Zoning Appeals. You make your application. The meeting is scheduled. There is a public hearing held, and then the Board of Zoning Appeals makes their decision. So it's a longer period of time to go to the Board of Zoning Appeals. There are notifications and public hearing and then a decision.
Give me a rough idea of what the time difference would be with the BZA special exception approval.
You're probably talking about 4 or 5 weeks, depending on when you get your application in for Board of Zoning Appeals approval. For administrative approval, depending on whether you you have all the information together, that could go through the process in a week. It could take a couple weeks. It just depends if there's anything that needs to be clarified when the application is submitted.
And is there a cost involved with either?
There is no cost specified for administrative approval, and there is a cost for Board of Zoning Appeals.
Which is?
I think it is $300.
And that's to cover the city's cost?
Advertising
Cost of
costs.
advertising.
And there's no way around that?
No.
The mayor asked a question earlier, actually more than one, but he asked a question earlier about the zoning changes and the definition of family and the special exceptions and how those all interrelated. Whatever zoning the city has in place, that can be overridden even further by a homeowners association?
The homeowners association have rules that the homeowner is responsible for. They're deeded, so there are restrictions that are in place. The homeowner is obligated to follow those restrictions, but those are not restrictions that the city would enforce. Those are restrictions the homeowners association would enforce. If the city's zoning changes to allow something that the homeowners association restrictions don't allow, it doesn't affect the homeowners association restrictions unless they're in some way tied to the zoning ordinance.
The mayor also asked a question about how do we know when a property changes hands, if it's already been approved for the rumor or any situation. That has to be recorded on a deed.
It does, and we have a very good tax assessment office, and those folks do regularly research the records in the courthouse for changes of that nature. So we would know that for purposes of our tax records. It would be incumbent upon the zoning administrator or someone else in the planning department to keep track of that.
Do we have any idea how many homes in the city currently rent rooms to roomers?
No.
Ballpark?
Anyone can rent one
Well,
room
more
to
than
one
one.
roomer, and there's no way the city does or can track that.
Any kind of special approval?
I think Reed said
Well, the special approval, we have approved, we have essentially two approved residences in the city, one on Cole Lane for 2 roomers and one on Matoka Court for up to 4 roomers.
So nobody's been renting rooms to roomers more than one person that we know of prior to the zoning changing?
only the property at Matoka Court, and they currently have a special exception that was approved.
No, I mean prior to the 1991.
No, I don't know of any.
Okay. So we're talking about basically 2 situations. And let's say there was a change, or let's say more people started opting for, even if we kept it the same and more people started seeking BZA special exception, how onerous a task would it be on staff to periodically, every 1 year, every 2 years, just check the deeds or the recorded, what we have recorded in the tax assessment system of those people who've received that special approval?
Well, since there's only 2, it shouldn't be very onerous.
Well, that might suggest that that be something we consider as part of whatever we do today. These 2 questions build a little bit, or maybe they're similar to questions the mayor asked, but I just wanted to clarify something. In the situation as it exists currently, which would be the case if we went with alternate 1, no change to the existing zoning, a couple or a family living in a home could only rent to 1 person without going to the BZA for special exception approval.
That's right.
And paying that $300 to go through the process.
Yes.
If an individual lived in the home, whether that individual owned the home or was a renter, they could rent to 2 people.
That's right.
Without getting any approval from anybody.
That's right.
And it's perfectly acceptable. So because the one owner is a couple or one other entity residing in the home is a couple, it's more difficult for them than it is for a single person.
Yes.
If the home is owned by a corporate entity under the current guidelines, and there's 1 person residing in the home, they can also rent to 2 people.
If they own 51% of the corporate ownership, then yes, they can.
I think that's it.
Thank you. Thank you, Mr. Briley. Scott?
Read and maybe pose this to some folks that have been in Williamsburg a lot longer than I have. Can you give us the historical use of this type of housing, throughout all our neighborhoods? Meaning, this is not a new thing, and it's only been on the books for so long that there has been an approval process. I think Doug has had some experience with this on College Terrace. Clyde, I'm sure you know of some. This has been going on for a long time. Am I correct?
Yeah, I mean, renting, I would say renting rooms to roomers has been going on for a long time.
Right. It's not a new thing in a college town. Through conversations, I've heard many examples of this where it's been successful in the past, especially with houses close to the neighborhoods. Under option 3, can you explain?
Have to be met. There are no screening requirements in the proposed alternate 3, although the Board of Zoning Appeals, I think, as part of their review, would have the option to impose reasonable requirements, which could be screening if that was felt to be something that was needed per that particular case.
Very good. Very good. So let's say a house is approved for a permit and things aren't going well. What would be the process where a neighbor could lodge a complaint with the city, and how would that factor on approval of a permit?
What's on the books today allows for up to 4 roomers in an owner-occupied home.
Correct.
Under options, the other options today, what is the maximum of renters an owner could put in a home?
Alternate 2, there is a maximum of 2.
Right.
That's 2 less than we can have under our existing regulations. Under alternate 3, there is a maximum of 4, which is the same as we have in our existing regulations.
So we're not talking about increasing housing numbers of available rooms in this scenario.
No, it's no more than 4 existing or under alternate 3.
Okay. Just a technical question for Ms. Shelton. In this, there's some language about ownership needing to be certified. What does that mean?
That means that an attorney in town certifies to the city, and they do essentially a title report showing that the person who is applying for the special exception is the record owner of the property.
Right. And he would go to the courthouse and find out who's...
He would research the title and determine if there have been any transfers of that property to any third party of any nature.
And is an attorney the only one that can...
That's the way that it's drafted in the code.